Hi, everybody. My name is Taruna Agrawal. I'm a lawyer at Rise Women's Legal Center. A lot of the names look familiar, so I think a lot of you know who I am. Welcome to the session today where our speaker, JP Boyd, will talk about the upcoming changes to the Divorce Act. Before we begin, I would like to acknowledge that we're presenting to you from shared lands of Musqueam, Squamish, and Tsleil-Waututh and Kikite peoples. Our speaker today is John Paul Boyd. Everybody calls him JP, and I don't see him object to that, so we're going to go with JP for short. He's a family law arbitrator, family law mediator, and a parenting coordinator. He's the principal of John Paul Boyd Arbitration Chambers, provides services throughout Alberta and BC. He's also a counsel at the firm Wise, Schiebel, and Burkhauskas. I hope I haven't butchered that name, JP.
Close enough.
Just a few administrative things before we begin. You're all on mute. Feel free to type your questions in the chat box, and JP will get to them as he presents. So feel free to type them as they come up. And that's really all there's to it. I will let JP take it from here. So all yours.
All right. Well, hello, everybody. I'm glad to be here. I'd rather be there in person, but there's that pesky virus thing going on. But it's nice to scroll down through the list of attendees and see so many old friends. I should give a special shout out to Winifred. Hi, Winifred. It's been ages since I've seen you. Manjeet Channa, who I went to law school with. Hello to you, Nate, Debbie, David, all those other folks. So hi. Nice to be back in a virtual setting, I suppose, is the way to say it. So let me just share my screen and we'll get right to it. As Taruna was saying, feel free to ask questions. I'll get to them as and when I can. So anyways, feel free. So the new Divorce Act. In this presentation, I'm going to talk about the bill. I hope somebody gets the joke at point one because I can't see anybody laughing, which really sucks. I'm going to talk about new rules about jurisdiction, new duties of the parties, legal advisors in the court, the whole important stuff about parenting after separation, all of which has changed, moving after separation, and interjurisdictional orders about support. The materials you've got include my unofficial consolidation of Bill C-78 with the Divorce Act. And this is what that is. I'm particularly pleased with this because the federal government still hasn't, at least as far as I know, they still haven't put together a consolidation. And it's one of those things that I'm sure we're all looking for. And I've also provided an overview of Bill C-78 in relatively plain language, which you can also have a look at. Here's a picture of the consolidation. Some other resources to have a look at are Bill C-78, which is available on Canly. And that's the short form address, as well as the current Divorce Act, also available on Canly. Then one other thing that I would actually encourage you to have a look at when you have the time, it's not a priority, but get to it when you can, is the Department of Justice's Changes to Family Laws page, which is half sort of government promoting itself and half useful information. That's the address, and this is what it looks like. And so there is actually useful information for families there. But it's the information for professionals where you're probably going to want to go. Among other things, there's a document there called the Divorce Act Changes Explained, which go through each and every amendment and give an explanation about what's going on. In particular, you'll see this, where you've got the new section on the one side and an explanation with the old section on the other side. So it's actually a pretty helpful resource. So good for the federal government for putting that together. So let's talk about Bill C-78. So this bill was first introduced in 2018 in the spring. It cleared the Senate slightly more than a year later. We had royal assent within 3 days of it leaving the Senate, so that'd be on the 21st of June. Now, this thing was originally supposed to have come into force on Canada Day this year. But as a result of partly the coronavirus and partly provincial and territorial delays in redrafting local legislation local rules of court and local court forums to accommodate the changes that the Divorce Act require, the federal government decided to bump it all back. So it's coming into force now on the 1st of March, 2021. And in my last conversation with the feds, they didn't indicate that any further delays are likely. The major thrust of the bill is to make profound changes to the rules about parenting after separation and the language we use to talk about parenting after separation. And along with that comes an overhaul of the factors set out in the Divorce Act to measure the best interests of the child. New rules about mobility applications, terribly important, as well as a whole bunch of sort of tidying up of interprovincial and international obligations that Canada has. The good news, honestly, from the point of view of anybody who's a legal professional in British Columbia, is that essentially, what the federal government's done is they looked at the Family Law Act, said, hey, that's pretty good, and did a pretty massive cut and paste. So when you look at the changes to the Divorce Act, none of this is going to be hugely surprising. It's not much different than what's happened in Alberta, and I'll talk about that in a jiff, but it's the people in other provinces like, Manitoba and Ontario and I guess New Brunswick that are going to be, having to, get their tackle in order in fairly short order. So parenting after separation, the nuts and bolts are that we are, we have always talked about the parenting of children in terms of custody, access, and guardianship. And the very first federal legislation about family breakdown, the Divorce Act, wasn't introduced until 1968, if you can believe it. And interestingly enough, it was introduced by Pierre Elliott Trudeau, who was at that time serving as Justice Minister. And this time, the Prime Minister who's introducing it is, of course, his son. So when the first federal Divorce Act came into effect, it talked about custody and access. It didn't talk about guardianship because of the division of powers between the federal government and the provincial governments under sections 91 and 92 of the old Constitution Act. Guardianship is really something that relates to civil rights and matters of a purely provincial nature. And so that's why our old Family Relations Act talked about guardianship, and it's why the legislation in most provinces has that concept buried in its law. The old approach dealing with custody and guardianship and access is still used in a lot of the other provinces. So this move first actually happened in Alberta, if you can believe it, which introduced its Family Law Act in 2005. And the first thing it did is it got rid of ideas about custody and access in favor of an expanded concept of guardianship and guardians who are usually parents, but not always parents, sometimes include third parties, and guardians who have parenting time with their kids and exercise what they call the powers, responsibilities, and entitlements of guardianship. And it also talked about people who were not guardians who might have time with a child called contact. Now, if that seems familiar to anybody, it ought to, because that's the approach taken by British Columbia. So we followed the path that began to be laid by Alberta in 2013. When the FLA came into effect, replacing the old FRA. And like Alberta, all of the rights fall into the basket that is held by people who are guardians. People who are guardians are parents who live together during the life of their child, as well as other people who might be a guardian appointed by a will, a standby guardian appointed by a guardian, or another person who might be appointed as a guardian by the court. Guardians in British Columbia exercise parental responsibilities, and what they have when they have time with their child is parenting time. I have always been attracted to the idea of parenting time because, to me, parenting time, it's a task. It's an activity. It's an engagement. It's what you're doing when you're with your child. It doesn't have the same drive-by flavor that access does, right? And if you want that drive-by flavor, that's still there. It's in contact, right? Because in British Columbia, a guardian who has parenting time or parental responsibilities, or both, also has the right to get information about the child's well-being, health, education, welfare from other people. They also have the right to day-to-day care and control, and a right to a certain unfettered decision-making responsibility when the child is with them. But somebody who is contact not only does not have the right to get information about the well-being of the child, they also don't have day-to-day care and control of the child when the child is with them, and nor do they have the ability to make emergency decisions with respect to the child. So then the other major new innovation that British Columbia's Family Law Act introduced is, of course, that big test about relocation that appears in Section 60, 61, somewhere around there of the Family Law Act, right? So that was hugely important, and that was really appreciated by family law lawyers, because the only other big case on mobility was Gordon and Gertz, a case from the 1990s from the Supreme Court of Canada. And while that case is really important because it introduces the concept of the material change threshold for varying orders about children, what was useful about it is that it provided all of these factors that the court was to consider when somebody wanted to move away with a child. The problem is that so much time passed since the Supreme Court made that decision that, the factors wound up being twisted and bent and were capable of supporting any particular move. And I remember Rolly Thompson, who's a professor at Dalhousie, and Rolly gave a presentation to a bunch of lawyers once, and he read out a fact pattern and asked the audience to vote on the likely outcome of a mobility application. And the joke of it all was that, the majority of the audience is voting one way, but the court decides another, all of which was based on the flexibility of Gordon and Gertz. So when British Columbia introduced a statutory test to update the law on mobility, it was essentially addressing a problem that the Supreme Court had itself neglected to address, despite calls from courts of appeal from across Canada, including British Columbia, saying, you've got to fix this mess. We need a new direction about mobility. And so that's what we got with the Family Law Act. The next province to make any changes remotely in this direction was Nova Scotia, which introduced its Parenting and Support Act in 2015. And although they didn't quite hit the nail on the head because they still talk about custody, it's guardians who have custody and guardians who have parenting time with the child. And people who aren't guardians may have contact or something delightfully called interaction with a child. Not really sure what that's all about. But Nova Scotia's legislation also included a relocation test, just like what we did in BC. So let's move on to Bill C-78. Now, much like British Columbia's Family Law Act, which was the product of years worth of research, discussion papers, and all of that within the Ministry of Justice, C-78 didn't come out of thin air. It was the product of an immense amount of research, some of which was conducted by myself when I was at the Canadian Research Institute for Law and the Family, but other of which was conducted by important researchers like Michael Saini and Rachel Birnbaum and academics like Nick Balla and Rolly Thompson and Carol Rogerson. But tons of research, tons of time spent developing policy, consultations with stakeholders, users of the system, as well as the key federal, provincial, territorial consultation groups, academics, and everybody was involved in this. The public materials issued by the government say that Bill C-78 has 4 key objectives: to promote the best interests of the child, to begin to take some steps towards better addressing the problems associated with family violence, to help reduce child poverty, which is code for we have better enforcement of child support orders, and to, quote, make Canada's family justice system more accessible and efficient. What I find interesting about that last one is that a lot of the bill is actually devoted to encouraging resolution of family law problems out of court, just like the Family Law Act, because the federal government's own material recognizes that every other way of resolving family law disputes is cheaper and faster than resolving family law disputes in court. Go figure. So what we know, of course, is that the federal legislation can't talk about guardianship. That's something that's purely within the purview of the provinces. So, and it doesn't talk about people who are parents, because the Divorce Act only applies to people who are spouses and people who used to be spouses. And in that context, unlike in British Columbia, the federal meaning of spouse is limited only to people who are married to each other or who used to be married to each other. So we don't talk about guardianship. We don't talk about parents. Instead, we're talking now about spouses who can have parenting orders. Parenting orders and parenting plans are made up of decision-making responsibilities and parenting time. And if you're not a spouse, you might be someone who has contact. So far, this is looking and smelling an awfully lot like British Columbia's Family Law Act. And frankly, you're not going to have a problem following the bouncing ball. It's almost exactly the same. So this is good. There is also in Bill C-78 a new relocation test, right? It does not look much at all like what BC's test looks like, and we'll get to that in some detail. The other new things that are introduced by the bill are a list of the considerations and factors that go into making decisions about children's best interests. This is important because really, up until this point, it's always been the provinces who got into a discussion about children's best interests and talked about it in very long lists of factors. Even the old FRA went on and on and on about children's best interests. But the Federal Divorce Act, prior to Bill C-78, just said the court makes decisions about children based upon their own best interests. And the only qualifier to that was found in Section 16, sub 10, which is known as the maximum contact rule, which says something to the effect of bearing in mind the principle that the child should have as much contact with each spouse as is consistent with the child's best interest. But that was it. All of that has changed. And now there's also new duties on spouses to protect their children from the conflict of the dispute resolution process that they are employing. So I've already mentioned it, but a quick reminder, the Divorce Act only applies to people who are or used to be legally married to each other. People who aren't spouses can still ask for parenting orders just like they can under the current Divorce Act, but they have to get leave of the court first. Also, critical point, only the Supreme Court can make orders under the Divorce Act. The provincial court's competency is limited to the Family Law Act. The other thing is that as I get into talking about the numbers of the different new sections, you're going to see some pretty squirrely stuff happen. So let me just explain what's going on there. If you've ever had a look at the Income Tax Act, which frankly I don't recommend at all, you'll see that the sections are numbered not 1, 2, 3, 4, 5, but 1, 2, 3, 4, 4.1, 4.2, 4.21, 4.22, 5, 6, 7, 7.1, and so on. There's a reason why it's so weird. My personal preference would have been to just, screw all of that. We'll just renumber the entire thing so it goes 1, 2, 3, 4, 5, 6, 7, just like everything else should. The problem, though, is that if you do that, unless you are replacing the entire piece of legislation and starting from scratch with something new, if you renumber everything, all the old case law gets muddled up because now you have to be looking at essentially a translation between what was that section then and what is the section now. And so in the Divorce Act, what you will see that a new section that's introduced between Section 6 of the current Act and Section 7 of the current Act gets numbered 6.1. And then it goes on 6.1, 6.2, 6.3, and so on. So what you have is what I've described before is at the bottom there. The sections then, if you're adding a new section between Section 6 and Section 7, they would be counted as going 1, 2, 3, 4, 5, 6, 6.1, 7, 8, 9, 10, and so on. But it gets kind of weirder, right? You also see the same adding of decimal points in subsections and subparagraphs. So just get used to that. You will see, subsection B, subsection B.1, B.2, subsection C, subsection D, and so on. The other weird thing, though, when we get into Section 16 of the Act, is you'll see that they ran out of numbers. They had so much new stuff to add, and this is all the stuff about parenting orders, contact orders, mobility and stuff, that they ran out of numbers. And so when you hit 9, where you go after point 9, when it's a new section, is 9. It's like, so it goes 16.9, 16.91, 16.92, and so on until you get to Section 17. So the important point is, don't freak out when you see Section 16.92. There are not, in fact, 92 separate subsections. There's only a few of them. So anyways, that's how it goes. But like I said before, if you want to see something really crazy, go look at the Income Tax Act. It is a dog's breakfast. Horrible. So let's dive into the let's dive into the important changes. Some are more important than others. So the jurisdiction sections of the Divorce Act currently are sections 3, 4, and 5. Section 3 is about divorce proceedings between spouses who are married to each other and are asking for a divorce, as well as orders about things like custody and child support, all of which we refer to as corollary relief, because orders about spousal support, access, custody, and child support are all corollary to the federal government's authority over divorce under Section 91 of the Constitution Act of 1867. So that's why that's called corollary relief. So Section 3, divorce and corollary relief between married spouses. Section 4 is about the court's jurisdiction to deal with claims about corollary relief between former spouses, in other words, people that used to be married to each other but are now divorced. And then Section 5 talks about variation proceedings to change an order between spouses who used to be married to each other. Okay. Now, those sections don't just talk about the basic jurisdictional requirements. They also deal with weird stuff, like what happens if two spouses magically are able to simultaneously file a divorce claim on the same day as each other, but in different jurisdictions. So how does that get resolved? So now the new rules are that the federal court, not the BC Supreme Court, the federal court is part of a separate system that exists apart from the provincial system. So in BC, the lowest level of court is the provincial court, and above that are the superior courts, which consist of the BC Supreme Court and the BC Court of Appeal. Parallel to that, an entirely separate system are the federal courts, which consist of the federal court, which is a trial court, and the federal court of appeal. And then above both courts of appeal is the Supreme Court of Canada. So under the old legislation, when two people managed to start the same thing on the same day, the divorce claim would actually be heard by the federal trial court, which would be a disaster because that level of court doesn't have any particular expertise in making divorce orders. It's used to dealing with issues about immigration, copyright, admiralty problems, and all sorts of other weird stuff, but it really doesn't do a whole lot of family law work. So now the rule is that if spouses magically are able to start the same proceeding on the same day, the federal court acts, but all its job is to decide which court has the jurisdiction to deal with it. Under the new rules, the court in the jurisdiction where the child usually lives will have presumptively the right to deal with the claim. And if the federal court, that is, can't figure out where the child normally lives, then it'll be the place where the parties had their last common habitual residence. In other words, the last place that they lived together as a couple. Now, there are new sections. Right now, Section 6, which is being essentially preserved, Section 6 talks about what happens when somebody's making a claim that involves a child, and the child normally lives somewhere else in a different jurisdiction, right? So Section 6 is the section that allows somebody to say, hey, wait a minute, that claim about the kid needs to come where I'm living because this is where the child normally lives. Okay, so that section is staying the same, but it only talks about parenting orders. Parenting orders are only orders about parenting time and decision-making responsibilities between spouses, not about contact orders. And so we have a brand new Section 6.1 that allows somebody to apply for a transfer of a proceeding when the case is only about contact. There's a new section 6.2 that talks about what should happen when a child has been wrongfully removed from a jurisdiction or has been wrongfully retained in a jurisdiction. And essentially, somebody who lives in the jurisdiction where the child used to normally live can apply for an order making the case come back to where they are. Section 6.3 is a new one that talks about the ability of the Canadian courts to make a decision about a child who isn't in Canada at all. And essentially, in urgent and extraordinary situations, the court here can still make that order, but presumptively, no. So not much is changing here. There's some changes about the language. We now talk about habitual residents rather than ordinary residents, but don't sweat it. The really important thing to know is that cases no longer go to the federal court. The federal court's only role is as a traffic cop, saying which way the case is going to go. And then it's important to know about the new sections 6.1, 6.2, and 6.3, all of which generally deal with issues about where a child has been taken from where they normally are. Okay, the new duties. This is another part. Right now, the Divorce Act doesn't give anybody duties except for the court, and its duties are about whether it should give a divorce if it appears like a couple are able to reconcile, and of course, the obligations of lawyers. And the obligations of lawyers are really nothing big. It's about, you got to point out to your client that there are counseling services that exist that could help you reconcile, and we'll get to that in a little bit. So parties, though, have new duties under the legislation. So Section 7.1 says that a person who has parenting time, decision-making responsibility, or contact must exercise those entitlements in a manner that is, quote, consistent with the best interests of the child. Now, the best interest tests is now at Section 16 of the Divorce Act. Even though this section talks about the best interests of the child, this is not going to require somebody to turn to Section 16 and go through the considerations and factors when making an analysis. In fact, my bet is that there is no requirement to refer to Section 16 at all when considering whether a spouse or a person with parenting time has made that decision appropriately. It's not going to be measured under that test because that test only applies to the court and it's explicit. And we'll get to that in a second as well. And the other thing that's interesting on that note about Section 16 only applying to the court is that if you look in British Columbia, our best interest test under the Family Law Act applies to the court, but it also explicitly applies to parents. The Divorce Act doesn't do that. It does not require parents to apply the best interest tests when making a decision about children. So next new obligation is at 7.2. 7.2 talks about parties to a proceeding. If you're a party to a divorce proceeding, Section 3, a corollary relief proceeding, Section 4, or a variation proceeding, Section 4, you are required to protect the children of the marriage from conflict arising from the proceeding to the best of their abilities. This is brand new. We don't have any legislation federally about protecting children from conflict. This is really important because what we know about conflict is that children experience distress when their parents separate, regardless of how well-adjusted their parents are, even if they're separating like Gwyneth Paltrow does and consciously uncoupling. Children experience distress from that. Children also suffer serious short and long-term consequences of being exposed to their parents' conflict. So here is finally a federal mandate that says you have a job. Your duty is to protect the kids from your toxic conflict. And in fact, the government commentary to this new section says, quote, research indicates that children's well-being suffers if they witness conflict between parents during and after a separation or divorce. In the best interests of the child, parents must try to shield children from conflict as much as possible. Of course, some level of conflict is common between divorcing spouses, and it can be difficult to shield children completely. As a result, parties are only required to do their best. I think they should do more than that. I think they should really give it a good shot. Now, the reason why I've got that second bullet point is because that first section talked about persons, and now we have a section that talks about parties. And so this is important because party includes obviously spouse A and spouse B, but it might include anybody else who is asking for parenting time and decision-making responsibility as long as they are a parent, so a parent of the child who isn't married to the spouse who's involved in the divorce proceeding. If they are not a parent, but stand in the place of a parent, in other words, they're a parent-in-law, or they intend to stand in the place of a parent. So this would be somebody in a new relationship, or it's somebody who's applying for a contact order. And those are all really important things. And we're going to get to that in a little bit when we talk about who gets to apply for which relief about kids. So bear with me. Then we have section 7.3. And it says that the parties, not persons, the parties to a proceeding have to try to resolve corollary claims. And remember what those are: child support, spousal support, parenting orders, contact orders. The parties to a proceeding are required to attempt to resolve their corollary relief claims through a family dispute resolution process. Family dispute resolution process is defined in Section 2 of the new Divorce Act as including any out-of-court dispute resolution process, and the ones it specifically names are negotiation, mediation, and collaborative negotiation. Now, because there's no requirement that the out-of-court dispute resolution process be consensus-based or be non-adversarial, it also includes arbitration. So pretty much everything's there, including parenting coordination as a result. The government commentary to this says, and this is the important part because now we're beginning to touch on the family violence part. It says, dispute resolution processes are not always appropriate. For example, when there has been family violence or there is a significant power imbalance between the parties, court proceedings may be a better option. As a result, parties must only participate in a dispute resolution process, quote, to the extent that it is appropriate to do so. And that's the meaning of that last little part. Section 7.4 applies to parties and to persons. And this is a miraculously important section. And it says that parties or persons who are subject to a Divorce Act order are required to provide, quote, complete, accurate, and up-to-date information if required to do so. Well, that's fair enough. And one thing that I have learned after moving to Alberta is that not all jurisdictions take the same approach to disclosure as we do in British Columbia. My impression in British Columbia was that if a document was relevant, one person would ask the other person for it. And if the lawyer was receiving the request and they were at all remotely reasonable, they'd say, yeah, sure, here you go. I'll get it on your desk in a couple of days. Not so in other provinces. In Alberta, for example, some lawyers make it a habit to deny what seemed to me to be like really obvious requests for disclosure until they're ordered to do so, which is dumb. But 7.4 is aimed to avoid some of that. So the question is, where are there requirements to provide information? They appear at a few points. Section 7.8 is a section of the new Divorce Act that allows the court to ask for information about civil protection proceedings, child protection proceedings, and criminal orders. Good. Section 16.4 says that a person who has parenting time or decision-making responsibility is entitled to information about a child's well-being. Sections 18.1 and 19 are the interjurisdictional sections that deal with child support and spousal support orders, and obviously there's an obligation to provide financial information there. And then, of course, we have the obligation to produce income information under Section 21 of the Child Support Guidelines. So this is really codifying something that ought to be common sense and is common sense in British Columbia, but not necessarily in other provinces. Section 7.5 and blows my mind because it's entirely redundant. It says that if you are subject to an order, you are required to comply with the order. That's kind of obvious. Everybody ought to know this. Don't know why this is here, but the government commentary says some people do not comply with orders relating to parenting or support. And that's why we have contempt applications and the Family Maintenance Enforcement Program. Government continues saying the amendment aims to encourage compliance by clearly stating the obvious. Okay, so good. New duty at Section 7.6, a party who is commencing or replying to a proceeding is required to sign a statement, just like the one that lawyers sign now, saying that they are aware of their duties. They don't have to say that they've complied with them like lawyers do. They just have to say, yeah, I know about these duties, and that's it. Lawyers and other legal advisors, quote unquote, have duties under Section 7.7. Now, the definition of legal advisor appears at Section 2, and it says a legal advisor is, quote, any person qualified in accordance with the law of a province to represent another person before the courts in a province. That's important because under the old Section 9, which is what this section used to be, the old Section 9 referred to every barrister, solicitor, lawyer, or advocate. And obviously, the difference between being an advocate is that you all are quite likely advocates within the meaning of that term. An advocate isn't a legal term with a defined meaning. To advocate means to argue on behalf of. So my child is advocating for themselves when they ask for another gummy bear or another hour of Call of Duty, right? So using the phrase legal advisor is a clear flag that the federal government is acknowledging efforts like what we see in British Columbia to license people who aren't lawyers to provide some modicum of legal services, but it doesn't apply to people who are not qualified in accordance with the law of a province to provide those legal services. So the good news is it doesn't apply to you, not yet. Not until the law changes to allow you to provide legal services representing someone in court. Okay, so good enough. And the old Section 9, by the way, which Section 7.7 replaces, Section 9 has been repealed. It no longer exists in the legislation. So let's get back to 7.7. 7.7 says that a legal advisor who acts for a spouse, right, somebody who's married to each other, is required to point out the parts of the act that talk about reconciliation. Yay, that's what we have to do anyways. They have to discuss the possibility of reconciliation and the possibility of counseling, which is already what we have to do. Yay. Carrying on, a legal advisor who acts for a person as opposed to a spouse is required to recommend that they attempt a family dispute resolution process. And remember, that's negotiation, mediation, and collaborative processes by definition. They're required to recommend that you try that. They're required to recommend that you attempt or consult family justice services, whatever's available in your province. That's kind of the same thing that the section already says, but it's making it clear that we're talking about family justice services. And a new requirement, you have to point out the parties' duties under Section 7.1 to 7.5 of the Act. And legal advisors are required to certify that they have complied with these things, as they already are. The court has new duties, however, and those appear at Section 7.8. I'm going to read this because it's super important, okay? So at 7.8 sub 2 reads as follows: in a proceeding for corollary relief and in relation to any party to that proceeding, the court has a duty to consider if any of the following are pending or in effect, unless the circumstances of the case are of such a nature that it would be not appropriate to do so. A civil protection order or a proceeding in relation to that, a child protection order or a proceeding in relation to that, or an order, proceeding, undertaking, or recognizance in relation to any matter of a criminal nature. It continues on saying, in order to carry out this duty, the court may make inquiries of the parties or review information that is readily available and that has been obtained through a search carried out in accordance with provincial law. Okay, that was really long-winded. But what this is doing is it's doing the same thing that Section 51 currently requires, the Section 51 of the Family Law Act. It's doing the same thing it requires in terms of the documents that somebody who's asking to be appointed as a guardian must produce and attach to their affidavit. And if you recall, Section 51 of the Family Law Act requires somebody who's applying to be appointed as a guardian to produce a criminal records check, a civil protection registry record check, and a child protection registry record check. So this is merely mirroring that, but you have to read it very carefully, right? So this is not about people who are applying to be appointed as guardians because the court doesn't have that power under the Divorce Act. It's about spouses and anyone who is asking for a corollary relief order. I think we can confine it and ignore child support and spousal support, but we most certainly have to look at it when we're looking at people who are asking for parenting orders and contact orders, right? And so in a case like that, the court is required to consider if there's any personal protection orders, criminal protection orders, like a no-go order or no stalking order and stuff like that, as well as anything that's a child protection order, any other criminal matters. So the point is to encourage the court to consider all of the different aspects of what might be going on in a family's life. And really, this all comes down to the tragedy in Oak Bay several years ago, where a person who was given custody of his kids killed them. And upon review, it was found that the court did not consider that individual's history before it made the order. And that's the kind of paternalistic motive that's behind Section 51 of the Family Law Act. And apparently that idea found fertile ground with the federal government because they've included something like that. Now, the reason why the court has to make inquiries of the parties is because most provincial and territorial justice computer systems are just as bad as the one in British Columbia, because the one in British Columbia doesn't necessarily link one case to another. I mean, all it takes is a misspelled name or a missing initial or the reversal of a middle name and a first name for the court system to be entirely useless. And there's no way to automatically make sure that you're correctly identifying a party to a criminal proceeding as being a party to a child protection proceeding or to a family law proceeding. And so as a result, the court may have no effective way of knowing whether or not the parties before the court are involved in criminal proceedings relating to family violence. And so it has to ask, and it's got to review information that is readily available, because otherwise it would be required to undertake a pretty massive search that would use up resources that the federal government doesn't have the power to allocate. And so really, the purpose of this is to focus the court's attention on certain aspects of the best interest tests, namely the parts that talk about family violence, and I'm going to get to them in a minute, at section 16, sub 3, sub J, and section 16, sub 4. I'll get to that soon. Next, the court does have other duties, and these duties continue, and they really aren't changed, but I just thought I'd mention them just to round everything out. So first of all, the court's existing duties under Section 10 are to be satisfied that there isn't a possibility of reconciliation before making a divorce order, and to encourage people to try to reconcile if it thinks that there's a chance. The other parts of Section 10 that are important are the parts that say that you can't subpoena a marriage counselor and force a marriage counselor to give evidence. And then at Section 11, it's the bars to divorce if the court believes that there has been collusion, connivance, or condonation in respect to an application for divorce. In other words, trickery aimed at tricking the court into giving you a divorce order. And the other, Section 11, a requirement that the court can't give you a divorce order unless an adequate amount of child support is being paid. So those are the new duties, 10 and 11. Largely, well, they are virtually exactly the same as current 10 and 11. Section 9 has been repealed. It's now been moved to Section 7.7. That's about it. So the really important stuff, to my way of thinking, is this, the parenting after separation stuff. Now, you've got a huge advantage here in British Columbia that you have over any other part of Canada except Alberta, because this new language isn't frightening and it's not new. It's what we use in Alberta. And so the Bill C-78 ditches the terms custody, custody order, and access. In their place, we have a contact order, which is a drive-by sort of time with the child, which is exactly like contact orders under the BC Family Law Act. We have decision-making responsibility, which is pretty much exactly the same thing as parental responsibilities under the Family Law Act. These are responsibilities for making significant decisions about a child's well-being, including health, education, cultural activities, extracurricular activities, the whole ball of wax. Parenting time is exactly what parenting time is under the Family Law Act. It's the time, in this case, that a spouse is with a child, not a guardian. And parenting orders are orders under 16.1 of the Act, which talk about orders for decision-making responsibility and orders for parenting time. So these are really the nuts and bolts, right? And so just paste into your mind these new terms. Good news is they're almost exactly what we have in British Columbia. We have a question from Hillary. I've always been curious, says Hillary, what circumstances would collusion come into play regarding divorce? Fascinating question, Hillary, and I'm delighted to answer that question because I am a total nerd. So once upon a time, prior to 1985, divorce was actually hard to get. You could only get divorced because of fault, the misbehavior of one particular spouse. And you had to prove that. So back in the old days, there are stories about lawyers in court who would race each other to get a divorce decree as soon as possible. But you'd be up in court handing Polaroids up to the judge, showing your spouse caught in flagrante delicto having sex with someone else, right? So the idea of collusion, right, it's about colluding, each spouse colluding with the other in order to meet the grounds for divorce. So it could be, Frank, go have sex with Julie next door, come on back, and we'll apply for a divorce based on adultery. That's collusion. Nowadays, collusion is kind of irrelevant, but what it's going to, though, is the inherent discretion that the courts have to give or refuse divorce orders, right? Because they really are discretionary. The court has to be satisfied that the criteria to make a divorce order set out in the Divorce Act have been met before it can grant a divorce. And the reasons for that are ancient, and they go back hundreds, if not thousands of years, to the obligations that one spouse had to another under the common law, merely by virtue of their marriage, and the catastrophic change in status that would result from divorce orders. And so the thing is, way back when, all that stuff about collusion, connivance, condonation, all had enormous relevance because divorce was at one point hard to get. Nowadays, not so hard to get. Not so important. Collusion, interesting, but not common. All right. So thanks very much for that, Hillary. I really enjoyed that. That question. So continuing on with new concepts. Well, we've already talked about family dispute resolution process. Out-of-court dispute resolution processes, including negotiation, mediation, collaborative negotiation, and arbitration, and parenting coordination. Family member is a new term, and it's been introduced for the same reason that family member was introduced as a term to the BC Family Law Act, namely for the purposes of the parts dealing with family violence. So a family member is defined as a member of the households of a child of the marriage or of a spouse, including new romantic partners who also participate in household activities. Really important one is the definition of family violence. Remember that the current Divorce Act doesn't talk about family violence at all. So there's no definition. So this definition needs to be read just the way the definition of family violence in the Family Law Act needed to be read, because you need to understand what it means. It's not just, and I apologize, but this is the trite impression of family violence, is that we're only talking about hitting and punching and things like that. In fact, we're not. We are talking about conduct that is violent, sure, but also conduct that is threatening or constitutes a pattern of coercive behavior that causes a family member to fear for their own safety or for the safety of another person. The definition explicitly references sexual abuse, harassment, financial abuse, psychological abuse, and a failure to provide the necessaries of life. So all of this is very much like the BC Divorce Act, the BC Family Law Act. And the one thing to point out is that the BC legislation is almost unique, I think, in Canada in referencing coercive control in the context of family violence, right? The Alberta Protection Against Family Violence Act, for example, is silent on that, right? The Alberta legislation talks about physical abuse as well as threatening, but it doesn't talk about coercive control. And as those of us who work a lot in family violence know, coercive control is a truly insidious form of family violence that is often unnoticed and unreported. So it's important to be aware of that. So this is good. On the whole, this is good. It's not a perfect definition of family violence, but it's better than not having one at all. And it's certainly better than what we have in Alberta. Carrying on, a new term, relocation. Remember this one, because this test has to be met before it qualifies as a relocation for the remainder of the act. And BC has the same approach exactly. There's a test for a move that does and does not qualify as a relocation in order to trigger the mobility test. So federal law is this. Relocation is a change in the residence of a child of the marriage or of a person with parenting time or decision-making responsibility that, quote, is likely to have a significant impact on the child's relationship with not all other people, but a specific range of other people. Persons with parenting time or decision-making responsibilities, usually but not always the other spouse. A person with a pending application for a parenting order. So somebody who is not yet a spouse or may not yet have parenting time, but they're asking for it, and somebody with contact. That's almost the same list as what we see in BC. The only thing that isn't missing from the BC definition is the reference in BC to persons who are significant in the child's life. Hillary has another question. Thank you. Hillary says, would failure to provide necessaries of life refer to family law or immigration or crossover with sponsorship breakdown? Well, maybe, possibly, I don't know. There is an obligation under the criminal code for adults to provide their spouses or common law partners with the necessaries of life, and an obligation to also provide the necessaries of life to one's own children. Failure to meet that obligation is a criminal offense. That criminal code provision doesn't come out of thin air. Those obligations are actually part of the common law obligations that we had prior to the Divorce Act to provide the necessaries of life for our spouses or for our children. So in this context, a failure to provide the necessaries of life, when you're thinking about it in terms of family violence, implies a willful withholding of food, of clothing, of shelter to achieve a purpose, I would imagine. But the issue about sponsorship is another animal entirely. The obligation that a spouse has who has sponsored somebody into Canada isn't to the person they have sponsored. The obligation is to the government because it's part of the terms on which the immigration was allowed. So I wouldn't go too far down the path of assuming that this has a immigration law crossover. I don't believe that it does. And that's primarily, if not only, because that obligation, the obligation that exists elsewhere. And it's not an obligation to one's spouse. It's or the person you've sponsored. It's an obligation to the government. So hopefully that answers your question. So let's move on to the best interests of the child. So here's the really, really important stuff. And I can't tell you how important it is that you read section 16 from the beginning to the end, and you read it very carefully. So under subsection 2, the court is required to give primary consideration to the child's physical, emotional, and psychological safety, security, and well-being when considering the factors. So that's important because what section 16 sub 2 is doing is it's establishing a list of primary considerations. So the primary factors are the child's safety, security, and well-being viewed through the lens of their physical and emotional and psychological welfare. The factors, which look just like the factors that we see in the Family Law Act, are itemized, enumerated at section 16 sub 3. They include, but are not limited to, the child's needs in light of the child's age and stage of development, the nature and strength of the child's relationships with spouses, siblings, grandparents, and, quote, any other person who plays an important role in the child's life, each spouse's willingness to support the child's relationship with the other spouse, the history of the child's care, the child's views and preferences unless they cannot be ascertained. So let me pause here and say also this. The cool thing about BC's Family Law Act is when it was talking about the best interests of the child, it made hearing from children a rebuttable presumption. In other words, it created an assumption that you will hear from children. This is mandatory unless you can rebut it. And the way you rebut that presumption under the Divorce Act is by showing they cannot be ascertained. And it's up to you as the person who doesn't want the children's views to be heard to show we can't ascertain them. You got to prove that. Otherwise, according to the Divorce Act, they will be heard. This is hugely important and represents a significant step towards our compliance with Article 12 of the UN Convention on the Rights of the Child. Article 12 says that the state must guarantee to children the right to express their views and preferences towards a court or a administrative tribunal that is dealing with a matter affecting their interests, unless the child doesn't want to do that. That's really important. Carrying on, child's cultural, including the child's Indigenous heritage, plans for the child's care that are expressed by each spouse, the ability of, quote, each person in respect of whom the order would apply to care for and meet the needs of the child, the ability of each person to communicate and cooperate with each other, the presence of family violence, and I'll get to that in a second, the presence of family violence and its impact on someone's ability to care for a child, and any civil or criminal protection or civil or criminal proceedings that are relevant to the safety, security, and well-being of the child. So let me just stop and unpack this for a bit. So what's really neat about these factors are that the tests are not just mechanical things like, what are your plans for the child's care? What were your plans in the past? They also include factors that relate to the spouse's relationship with each other and their individual relationships to the spouse. And I love that they include the spouse's willingness to cooperate with each other, their ability to cooperate with each other, and their ability to promote the child's relationship with the other spouse. That's hugely important. Now, and then the last bullet point on this slide relates to that really broad definition of family violence. And it's what I was talking about when I was talking about the Divorce Act in comparison to Section 51 of the Family Law Act, that new obligation to consider everything else, other legal proceedings that are relevant to the child's safety. So it's criminal matters that are obviously related, child protection proceedings, and any civil protection proceedings that are relevant, right? So that's important. The other thing is, in the Family Law Act, family violence is one of the factors to be considered. And if family violence is a factor, the following section of the legislation spells out a long list of additional factors the court has to consider. This operates just like that, except that instead of finding those factors in a new section altogether, the factors appear at section 16 sub 4. So going through the list of best factors in 16 sub 3, if family violence is a factor, you have to turn to the next section, 16 sub 4. Those factors are these: the nature, seriousness, and frequency of the family violence, whether the family violence demonstrates a pattern of coercive control, whether the family violence was directed to a child or whether the child was merely indirectly exposed to the family violence, harm or risk to the child, compromise to the safety of the child or a family member, steps taken by the abuser to prevent further family violence and improve their ability to care for the child, just like the BC Family Law Act, and any other relevant factor. So read section 16 carefully. So getting in then to the orders that the court can make, they start at section 16.1, which talks about parenting orders. Orders for parenting time or decision-making responsibility can be made by applying under section 16.1 by a spouse who have presumptively the right to do this, but also by other people. And this is really wacky, but you got to read this carefully. A person who is not a spouse, who is a parent of the child, right? So parents have had a child, parent gets married to somebody else. These two people are spouses, but not these two people. And so it's a parent who is not married to a spouse who is applying for care of the child. Also, a person who is not a spouse who stands in the place of a parent, right? So that would be an in-law of some nature, or someone who intends to stand in the place of a parent, which is really another category altogether. Parenting orders can be made by the court, by the Supreme Court only, to allocate parenting time and allocate decision-making responsibilities, just like under the Family Law Act. The court can impose requirements, terms, and conditions on communications between spouses and any person with contact or persons with parenting time or decision-making responsibility. The court can direct that people participate in a family dispute resolution process, which is huge but also mirrored by BC's Family Law Act. And among other things, the court can make an order that prohibits the removal of the child without consent or a further court order. Parenting orders under Section 16.2. A person with parenting time has the exclusive authority to make during that parenting time day-to-day decisions affecting a child. Now, what the government actually means by this is more orders on an urgent basis as well as mundane humdrum stuff. So you may have, as a spouse, an order allocating decision-making responsibilities that, for example, talks about the child's diet or child's health care. But when the kid's with you, you can make mundane decisions like whether the child should wear sandals or rubber boots or mucklucks. You also have the ability, though, if the child breaks their arm, to take them to the hospital and get them treated, even if you happen not to have decision-making responsibility over health care, right? So, in other words, orders about decision-making responsibilities aren't a suicide pact. Section 16.2 sub 3 lets you make decisions when you have to, even if you don't have that official responsibility. Section 16.3, the next section, allows the court to allocate decision-making responsibilities between spouses to both of them, just like the Family Law Act, or to those other people who are a parent but not a spouse, stand in the place of a parent to the child, but are not a spouse, or intend to stand in the place of a parent or who are not a spouse. 16.4 lets the court make orders about parenting time, not presenting time, sorry for the typo. And it says that people who have parenting time or decision-making responsibilities may ask for information about the child's well-being, and it says including the child's health and education. So broad, unfettered right to ask for information about the child's well-being, specifically naming health and education under that general heading. The interesting thing is the entitlement or the ability to ask for that information extends to anyone who happens to have it. So it's not just the other spouse or the other person, but it's also doctors, teachers, dentists, and candle makers, right? The whole ball of wax. Anybody who has the information, if you're someone who has parenting time or decision-making power, you're entitled to ask for that information and get it. Section 16.5 is the one that talks about contact orders. This is exactly the same way as contact orders work under the Family Law Act. This is a drive-by. Somebody who has contact is usually not going to be a spouse. In fact, they will always not be a spouse. Somebody who has contact can get an order for contact, an order for visiting time, an order about when contact communication can occur. The court can impose terms and conditions, including an order that the person not remove the child without consent or an order. But most importantly is all the stuff that this person doesn't have. Somebody with contact does not have exclusive authority to make day-to-day decisions affecting the child and does not have the ability to get information from anyone about the child's health or the child's well-being. Finally, new term, parenting plan. Parenting plan is defined at section 6.6 as a document or part of a document that contains elements relating to parenting time, decision-making responsibility, or contact to which the parents agree, which by definition means that it's a separation agreement of some sort or a parenting agreement, call it what you will. It's a written contract. The court is required to include the parts of an agreement that are parenting plans in a parenting order it makes or in a contact order it makes, unless it's not in the child's best interest to do so. This then is the vehicle through which a disgruntled spouse is going to attack a separation agreement with which they are unhappy. And the test is to say that it is not in the child's best interests. Remember that the court is not bound by agreements, only the parties are. So, and if the court agrees that the parenting plan is not in the child's best interests, it can make modifications to the plan such as it considers to be appropriate and include the modified plan in the parenting order. In other words, it can do whatever the hell it wants and include whatever the hell it wants in the court order. So please feel free to ask questions because we're now going to move on to the next bit, which is about moving after separation. And if I see something pop up, I'll stop and we'll address that. And let me also just have a quick glass of water. All right, moving after separation. Just like the Family Law Act, there are moves that qualify as relocations and moves that don't. So, and in fact, let me go back and we'll just refresh ourselves on what the meaning of relocation is, because this is central to all of this. Relocation, where are you? Sorry, just give me 1 second, everybody. Is it here? Yeah. Relocation, a change in the residence of a child of the marriage or of a person with parenting time or decision-making responsibility that's going to have a significant impact on a child's relationship with other people with parenting time, decision-making responsibility, or contact. All right. So moving back. Moves that are not relocations are addressed in section 16.8. So in other words, this is a move that isn't likely to have that significant impact. Even if you're planning on moving, so this would be a move within the same city, the same town, roughly the same area, somebody with parenting time or decision-making responsibility who plans to move with or without the child, just like in British Columbia, is, required to notify other people with parenting time, decision-making responsibility, or contact of their intent to move. Just like in British Columbia, they are required in that notice to specify the date and the time of the move, the place of the new move, and their new contact information at the new place. Just like the Family Law Act, this must be in writing. The court, just like the Family Law Act, can grant an exemption from the notice requirement if there's a risk of family violence. So what you would do to manage this is you would be making an ex parte order for permission to move under section 16.8 on the basis of the risk of family violence. And you'd be doing it on an ex parte basis because you're going to be afraid of the risk of family violence, of course. Now, if a move is going to have that kind of significant impact on the relationships with other people, section 16.9 takes over, and this early part is going to sound just like what you see in the Family Law Act. So, a person with parenting time or decision-making responsibility who wishes to relocate with or without the child, just like the Family Law Act, has to give 60 days notice, just like the Family Law Act, to any other person, but not every other person, only people who have parenting time, decision-making responsibility, or contact. So, to be clear, it is a relocation if the effect of the relocation is likely, not guaranteed, but likely to have a significant impact on people who have parenting time, decision-making responsibility, or contact, or who are applying for parenting time or decision-making responsibilities. People that only have contact don't have to give notice of the move. Only people who have parenting time or decision-making responsibility. When they are making a move and the move qualifies as a relocation, the only people they have to give notice to are other people who have parenting time, decision-making responsibility, or contact. That's it. Nobody else is entitled to notice. The notice that you are required to give must be in writing, just like the Family Law Act. You have to state the date of the proposed relocation, the new address and contact information if the move is permitted, as well as you have to give a proposal for how parenting time, decision-making responsibility, or contact could continue to work after the relocation happens. So far, so good. This all smells and feels a lot like the Family Law Act, and after, 7 years, we should all be familiar with how that works. Now, here's the rest of it. Someone who has contact is entitled to notice, and they're entitled to that notice 60 days before the move happens. But just like the Family Law Act, they have no standing to object. So they get to learn about it, but they can't do anything about it. On the other hand, if you are a person with parenting time or decision-making responsibility, you are entitled to those 60 days notice. But if you don't object, what happens is that the court may authorize the move with no further notice to you. So the person who wants to relocate may relocate if, 1, the court has given authorization for the move to occur, or 2, a person who has received notice, who has parenting time or decision-making responsibility, has not filed an objection to the move within 30 days of receiving the notice. Okay, so that's hugely important. And the other part of that second sub-bullet point is that if there's an order a pre-existing order that prohibits the relocation can't happen, right? So if you're a person and you get notice of the move, you don't necessarily have to object, although I would, just to be careful, if there's an existing order that says you can't move, right? Okay, so what's important about this, unlike the BC Family Law Act, is the Family Law Act doesn't specify any particular form of notice, right? We have case law that's built up saying that an email will do. We know that it needs to be in writing, but it could be an email, it could be a skywriter who's hired to paint a picture of the new home in the sky, whatever. But here, the federal government is working with the provinces and territories to create a specific form to give notice of the move. Okay, whatever. Okay, so section 16.92 prescribes a list of additional best interest factors, just like the Family Law Act, that need to be considered in addition to the Section 16 factors when a move is being contemplated. The additional factors include the reasons for the proposed relocation, the impact of the relocation on the child, the time spent by the child with each person who already has parenting time, and the level of involvement in the child's life of each of those persons, whether or not the person who wants to move has complied with the notice requirements, and whether there's an existing order, arbitral award, or agreement that restricts the relocation. So this really does look a lot like BC's law. What I like, though, is that, the fact that you have parenting time gives you the prima facie entitlement and standing to say, I object to the move. But when push comes to shove, the court's going to look at your involvement in the child's life. So if you are the sort of parent who has essentially a kind of hands-off relationship with your child, you can have parenting time, but maybe you don't exercise it. That's going to undermine your ability to object. So, when the court authorizes a relocation, if it does that, it could also make an order about costs relating to the exercise of parenting time. So if you move from Vancouver to Moncton, maybe the court will make an order about the cost of flying yourself and or the child to and from. Just like the Family Law Act, there's an additional discussion about whether the relocation is a change of circumstances that would entitle you to vary. And just like the Family Law Act, if a relocation is prohibited, that is not a change in circumstances. Now, here is the really weird part of the legislation. 16.93 sets out 3 different ways the burden of proof could conceivably be allocated. First, if the child spends a substantially equal amount of their time in the care of each party, the burden to prove that the move is in the best interests of the child lies on the party intending to relocate. On the other hand, if the party who is intending to relocate has the child for the vast majority of the child's time, the burden lies on the other party to show why the relocation is not in the best interests of the child. And in those cases that are in the middle ground, somewhere between substantially equal and vast majority, each party has the burden of showing that the relocation is or is not in the best interests of the child. So here's the part that just drives me bonkers. The child support guidelines contain a section on shared custody, Section 9. Section 9 says, if a parent has care and control of a child for 40% or more of the child's time, then it's a shared parenting arrangement, which triggers the discretion of the parties or the court to make a different order about child support than what the tables would require. What blows my mind, right, is that when it comes to the federal government making these decisions, we know what equal means. Equal is a mathematical concept. Is it 50% here and 50% there? We know what 40% means because after the child support guidelines came into effect in 1997, case law began to accumulate for years that talked about stupid, like how do we calculate the child's time? Who's entitled to the time when the child is sleeping? Who's entitled to get credit when the child is at school? But over the passage of time, we've had enough cases that talk about this stuff that we've been able to resolve. How do you count to 40%? We have figured this out, and we hardly ever find ourselves arguing about the 40% threshold anymore. So it is curious that the government chose substantially equal instead of either equal mathematic idea or 40%, on which we already have a substantial body of case law, or the vast majority. We know what majority means. Majority is 50% plus one, right? But the government chose vast majority for some reason. And so the reason why this is vexing me to no end is because, among other things, when I think about access to justice, I think about laws that are clearly understandable, and can be applied by ordinary citizens in their day-to-day lives, right? I also think about laws that are clear and direct, such as you may cross the street when the light is green, right? If the light isn't green, if it's any other color, you can't cross the street. It's clear. But not a law that says, well, if the street light is sort of green or not quite yellow, I mean, that's just totally ambiguous. And so the problem with phrases like substantially equal and vast majority is that they are not defined. They don't appear in any other legislation, and there's nothing that we can look to, never mind us who have involvement in the legal system, but the average person on the street. There's nothing for them to look to say, do I have the vast majority of my child's time or not? Right? And I remember the case law that came out on this issue under the Family Law Act. Some cases decided that, oh, well, you've got the kids for 3 days out of every 10. That sounds like the majority of the child's time. And other cases had a much different threshold. And so this is that same problem. And so what bothers me is that using language like substantially equal and vast majority, this is a recipe for conflict. And because it's asking us a question that people cannot figure out on their own, it's going to be driving people towards court. And I do not think that family law cases are best resolved in court, hardly ever. Maybe in cases of family violence, maybe in cases where there's threats being made to people, animals, or property, but in general, we ought not be dealing with family law cases in court. But when you have a separating couple and they can't make the decision about, is it substantially equal or is it vast majority or is it somewhere in between? Where are they going to go? Well, they don't have any case law to rely on, so it's going to be court. And that's a real shame, especially when there are tools and definitions available out there that the court could have chosen. Now, in fairness to the government, and as I step off my high horse, and for which I apologize, in fairness to the government, there are a long list of decisions made by Claire LaRue Dubé, Beverly McLaughlin, and others that talk about the importance of taking a highly contextualized analysis, and Gordon Gertz is one of them, ironically enough, that talk about the importance of the court taking a contextualized view so that it doesn't apply a cookie-cutter approach to the children who come before it, but the approach it takes is a contextualized approach, looking at the circumstances and needs of the specific child in the specific family, in the specific circumstances that bring the matter to the court. And that's why government specifically elected to use these waffly phrases like substantially equal and vast majority. The problem from my point of view is that we're sacrificing the important need to address the resolution of a mobility issue in a cheap and affordable way out of court with the requirement for that highly contextualized analysis. So clearly the priority is on the contextualized analysis. I'm just not sure in the grand scheme of things whether forcing people into a highly adversarial, never mind expensive and incredibly inefficient court system is the way to resolve these problems. In any event, that's where we are. Finally, and we're almost there, so you've done a great job if you're still paying attention, you're still online. I just want to briefly touch on some of the interjurisdictional things. So the current provisions for dealing with interjurisdictional orders on support, from a provincial law point of view, we have the Interjurisdictional Support Orders Act, which is in force in every territory in every Canadian province, as well as in other countries, including a lot of the United States, New Zealand, Australia, and a few other Commonwealth countries, right? That procedure under the provincial law is one-stop shopping. Basically, the application is heard wherever the respondent happens to live, not where the applicant happens to live. The old procedure under Section 18 and 19 of the Divorce Act is now gone. That procedure was kind of crappy because it called for a two-step process. First, you, in your home jurisdiction, applied for a provisional order. If you got that and you were required to give notice to the other side, then the provisional order went to the other jurisdiction for confirmation, which gave the person who was entitled to notice of that as well, not one, but two opportunities to have a kick at the can and argue about why this shouldn't happen. It was expensive and time consuming, right? And so the new procedure under sections 18 through to 19.1 is much closer to the provincial process than it is to the old federal process. It's much more like one-stop shopping than what we had before. Essentially, a spouse may apply for a brand new order, a variation order, or a recalculation by submitting an application to the provincial authority. The provincial authority takes that material, sends it off to the reciprocating jurisdiction, any other province or territory in Canada, and the authority who receives it gives notice of the application to the respondent, and the application is heard in the jurisdiction where the respondent lives. So theoretically, one-stop shopping, not so bad. There's a similar process that's available when the respondent lives in reciprocating jurisdictions outside of Canada, and that's the process that's dealt with at sections 19 and 19.1. Right, and there's that slide there. The remainder of the bill goes on at quite some length, dealing with Canada's other obligations to other countries under other legislation, including the Convention on the International Recovery of Child Support, the Convention on Jurisdiction Applicable Law Recognition, it just goes on, international conventions relating to family orders and agreements enforcement act, which relates to custody and guardianship and parenting time, as well as other matters. And then the last one there is about the garnishment of federal salaries in order to pay provincial orders. The bill does not address Canada's obligations under the UN Convention on the Rights of the Child, which we signed sometime in 1991 or 1992. That's a bit of a disappointment, but I am satisfied that to some extent, Section 16, the amendments to it, do provide the opportunity for children to be heard by establishing that rebuttable presumption in favor of hearing from them. And that goes some way, but I do wish that we were more blunt about things like children's right to counsel, the nature and extent of children's right to speak their piece, and the obligation of judges and lawyers and mediators and arbitrators to make a special effort to hear from kids. So I have talked at you for almost an hour and a half. I'm sure everybody's getting tired. And if you made it through this way, then this far, then congratulations, because I know this was dry and boring, and you're probably really tired of listening to me talk. So I'm happy now to stop and take whatever questions, comments, queries, and concerns that you might happen to have. Feel free to talk, ask questions, and go to it. So just so you know, I have both the Q&A box open as well as the chat box. And since I have the chat box open, I'm going to give another shout out to Manjeet Chana. Hi, nice to see you too. So please, if you have any questions, comments, concerns, have at it. Taruna, Shannon, I know that you're nurturing some questions that have been on your mind for possibly ages. If you have any, please spark them up.
I don't at the moment. We'll see if people type their questions.
Yep. Well, let's give it a few seconds, because it can sometimes take some time to type out a question when you can't speak it. Oh, we got one from Winifred. Hi, Winifred. Do you know when the revised forms are going to be made available? I do not. All I know is that the reason from the adjournment on the 1st of July was because those forms and the regulations that are required weren't yet available. I should say that in addition, to the new forms, which have to be recommended by the federal government and then adopted by the provincial and territorial governments through their equivalent of the rules of court legislation. In addition to that, we are actually getting, and this is hugely important, we're getting from the federal government a whole toolkit to help us better deal with family violence. The toolkit will include an actual instrument designed to be administered to ascertain the presence or absence of family violence, but more importantly than that, also a kit to help us understand what family violence means, how it impacts on people's decision-making capacity, imbalances of power, and all the rest. So keep an eye out for that. That's going to be super important. And again, just like Winifred's question about revised forms, I have no idea when that's coming. I dearly, dearly hope that we're going to get an answer at some point prior to the 1st of May, 2021. Sylvia has a question about domestic violence and moving. A parent with vast majority parenting time is in a new relationship. The relationship is abusive and the parent has to move with the children to be safe. Do they still have to give notice to the other parent? If yes, can the other parent prevent the move? So there are exceptions about all the notice requirements with respect to family violence. So if that issue comes up, you can apply to court on an ex parte basis for leave to have the application heard without notice to the other side. The court will, I have no doubt, require something along some strict proof that the family violence exists. And that's the kind of thing that maybe a court order, like an undertaking or recognizance might help. But more likely, we're looking at affidavits from witnesses, other third parties, affidavits from doctors, psychologists, counselors, other sorts of individuals. So don't expect that the threshold is going to be a light one. But on the other hand, if family violence is a factor, I would encourage everybody to take advantage of those provisions of the Divorce Act and seek exemption from those requirements if at all possible. My expectation, of course, is that just as the date of separation is often a trigger that exacerbates, if not causes, family violence, that moving applications, because of the risk they pose to the parent-child relationship, will be a risk just as important as the date of separation. David says, when there are no children involved or property, will uncontested divorces follow the same process? Yep. Same bat channel, same bat time. Everything will be the same. Hillary says, about access to justice, is there any chance that the new forms will be more user-friendly for the average person? Not sure if drafts of them are out yet. Well, I have a draft. I just can't share it with you. Just by the sheerest and weirdest chance, on Monday, I'm actually having a chat with some of my colleagues at the Department of Justice, specifically for the purpose of reviewing the extent to which the forms are written in plain language. There's a chance. I don't know if I'll succeed. The federal government and I do not often see eye to eye about things, but I promise you that I will make my best effort to sway them to a properly easy way of understanding way of expressing themselves in the forms. So Manjeet says, can you please elaborate on the definition of family member? So the family member definition is this. Family member includes a member of the household of a child of the marriage or of a spouse or of a former spouse, as well as a dating partner of a spouse or a former spouse who participates in the activities of the household. In plain language, this is not. And so what I meant in the slide by new romantic partners was my paraphrasing of the as well as a dating partner of a spouse or former spouse. And so there is no requirement from the plain language text of the definition at 2(1) of the Divorce Act that they be living together. They merely need to be dating, and they need to, quote, participate in the activities of the household. No idea what that means, but that could be something as de minimis as, yeah, I go to Safeway with them to buy groceries. Or it could be I mow the lawn and I live in their basement. I don't know. But the good news is there's no requirement of living together. And all we have to go on at this point until the court in its infinite wisdom goes on about this and drowns us in case law. It's the plain language of the text of the Divorce Act. Wendy says, would the offspring of a new romantic partner also be counted a family member for the purposes of family violence? Well, the definition of family violence begins, family violence means any conduct by a family member towards another family member. So I do not read that definition and the definition of family member as including children, right? It would be the case if they were a member of the household of the child of the marriage. So let me rewind. So taking Wendy's assumption that we have the spouse who's the subject of the litigation, and the spouse has got a new romantic partner, a dating partner of some sort. The dating partner is encompassed in the definition of family member if they participate in the activities of the household, whatever that phrase is later chosen to mean. But that definition includes a member of the household of a child of the marriage, which would include, if the dating person was living with the spouse, the dating person's child. So not directly and not automatically. That's the case where a cohabiting relationship would be required. And Manjeet says, so this is different than the FLA, which does not include dating relationships. Manjeet is absolutely right. It doesn't. One of the things that struck me as quite odd, but obviously intentional about the Family Law Act is that it didn't apply to people who were boyfriends or girlfriends. It only applied to people who were parents or spouses, which struck me as an interesting omission, but obviously one that was managed from a tactical purpose. On the other hand, that decision also meant that people were thrust into the tender arms of the criminal justice system and could not seek relief through the Family Law Act. But here, family violence would include people in dating relationships. But let's be clear, though, about the important distinction. Under the Family Law Act, there are specific remedies available under, what is it, Part 9, I think? Such as exclusive occupancy orders, protection orders, no-go orders, no contact orders, that are all available under the Family Law Act, specifically to people who qualify as family members where there has been family violence. The Divorce Act doesn't have that jurisdiction, right? The Divorce Act can only talk about matters that are related to divorce or a divorce or things that are corollary to the federal government's authority over divorce. And so the only place in the legislation where family violence comes into play are the questions about notice that has to be given when relocation is a question, or the best interests of the child test at section 16, sub 3, sub J. So even though Manjeet's right that it does apply to people in dating relationships, the scope of its application is really quite narrow. We're really talking about relocation, and we're talking about parenting orders and contact orders. So that is that. And thank you very much, Debbie, for the kind comment. I appreciate it. So I'm happy, again, to take anything. I mean, LSS, you've got me for another 28 minutes. If you need me, and I'm happy to sit here and answer questions about anything, really, preferably something relating to the Divorce Act. But if nobody has further questions, I'm happy to shut up and let you go home early. Well, I guess you are at home, so stay at home early.
One more question, Papa.
Judy, sorry, I've got a house fly. Do you think, says Judy, that more people will use the Divorce Act now in BC instead of just using the FLA for parenting issues and the Divorce Act just for divorce? Possibly. The thing has always been, particularly in BC, where we have always been much more comfortable with the overlap in subject matter between the Divorce Act and the Family Law Act. We've always been much more chill about jurisdictional issues. In places like Alberta, for example, they have a positive allergy to making orders simultaneously under the domestic relation legislation and the federal legislation. And so quite often when somebody's married and they get out of provincial court and somebody's applying, for relief under the Divorce Act, that's it. The Family Law Act is done and all of the parenting orders go under the Divorce Act. So I don't know how much it's going to change things in BC, but, as counsel, I was delighted when the Family Law Act came into force because it was and remains the most progressive piece of legislation on domestic relations in all of Canada. I'm so proud of this province for doing this. It was so forward thinking, and I was delighted to get rid of conflict-laden terms about custody and access that the general public didn't understand anyways, except that it meant win or lose. So this certainly makes the Divorce Act much more friendly to people who are interested in a more child-centered, less conflictual approach. I don't know that in BC in particular it's going to increase use of that because the Family Law Act is still better and still more useful in so many more ways. And of course, remember also that the Family Law Act is very much one-stop shopping. It deals with everything in a relationship, from property to spousal support to parenting decisions. The only thing it doesn't cover is divorce. And, you know, with the way that unmarried relationships, the last statistics I saw said that they were increasing at a rate that was more than 3 times the rate of new married relationships. So if the rate of disinterest in marriage continues, the Family Law Act may wind up winning the cake anyways. Anna says, if a mother without status in Canada wants to go back to her home country and has a newborn child, the father has not been in the life of the child, is not financially supporting her, can she still ask for an ex parte order to take the child with her? So first of all, the mother only needs an order under the Divorce Act if they are married to each other. Otherwise, the question falls under the Family Law Act. And under the Family Law Act, the question really hangs on whether or not the father is also a guardian of the child. So guardianship is specifically dealt with in the Family Law Act and specifically says that the parents of a child are guardians as long as they've lived together during the life of the child. There are other additions to that rule that talk about when a parent doesn't live with the other parent, but has, what do they call it, regular contact, something like that, or regular care for the child. So in a case like that, it is certainly possible that if the father qualifies as a guardian, the mother would need to apply for permission to go. Anna clarifies that there's family violence in this relationship. And so just like under the Divorce Act, under the Family Law Act, the mother could apply for leave to avoid giving notice and therefore just go. So yes, out of an abundance of caution, let me put this another way. A lawyer answering that question, the first question they would have is whether or not the father has standing as a guardian under the Family Law Act. So I'm going to whip out my handy dandy annual family practice. I'm going to whip over to the parts of the Family Law Act that talk about mobility. Section 60, 65, 66. Relocation means a change in the location of the residence of a child or a child's guardian. So we've hit the 2 buzzers on that. That can reasonably be expected to have a significant impact on the child's relationship with a guardian, one or more persons with a significant role in the child's life. So in this case, the father who doesn't see the child isn't a person having a significant role in the child's life. So that means that the only reason why the father would be entitled to notice is if the father stands as a guardian. That requires us to look over at section 30, that isn't it. I've been out of the province for so long, I'm forgetting where I find the definition of guardian. But it requires looking at that part of the Act, 31. It requires looking at that part of the Act to decide whether or not the father qualifies as a guardian. And so that essentially is what you would need to look at. Anyways, I'm not going to waste everybody's time trying. Section 39. Sorry. Boy, it's been a long time. While a child's parents are living together and after the child's parents separate, each parent of the child is a child's guardian. So they have to meet that test. And if so, he's a guardian entitled to notice. Then under section 39, sub 3, a parent who has never lived with the child, which may be the case for you, Anna, is not a guardian unless one of the following applies. The parent is a parent through assisted reproduction. That's not the issue. The parent and all the child's guardians make an agreement that the parent is a guardian, that's not likely to be the case for you. Or C, the parent regularly cares for the child. So under that test, first you have to ask, are they a guardian? If they're a guardian, they're presumptively entitled to notice. If they're not presumptively a guardian, then go to town. And according to section 66, they're not entitled to notice. So there you go. We'll just give it a few more minutes to see if anybody else comes up with a question, because I really am happy to talk about these things. And if not, y'all can hang up your browser. Okay, well, Taruna, is it time to pull the plug?
Yeah, I think so.
Okay.
You don't see anybody typing? Oh, yeah, Winifred says thank you.
All right.
Perfect.
Well, thanks very much, everybody. Appreciate your time and your attention. This was fun. Well, fun is a odd way of putting it. I had fun. You maybe not so much, but thanks.
Awesome. Thank you for presenting, JP. This was really informative.
My pleasure.
Attending, everybody.
Bye-bye.